Good afternoon, Mr. Previs again.
Good afternoon, Mr. Chairman. Peter Previs on behalf of the licensee. If I can explain the
Where
names.
is Mr. Simpson?
Mr. Simpson's partner is literally on his deathbed. I spoke with him Tuesday, and he had to take him to the doctors yesterday, and he said he's absolutely dying, like very, very shortly. And
Sorry to hear that.
thank you. And I explained to him that if the board wanted to confirm that he'd have his cell phone on, but that he's fully aware of the charges, and that Ms. Karen Rathbone, the general manager, is authorized to proceed in his behalf.
All right, thank you very much.
Thank you, Mr. I'm
Admission
sorry.
denial.
I have an unusual request, and I'll explain the reason for the request. But the bottom line request is I ask the board to consider dismissing this charge with a warning upon a payment of the $125 administrative fee. And the reasons are as follows. Number one, when the alleged incident occurred, the bar was recently purchased from Mr. Emery's estate, who passed away, and he had the Flamingo for years and years. The bar was recently purchased and the license was transferred, and there have been substantial renovations to the tune of $200,000. The bar configuration, as it was the bar took up the entire room, so that people were sandwiched in just to walk around the bar or to get to the side. The establishment, I'm not a great person getting things off the internet, but I just wanted to show that the place is totally opened up now, and they've done a fantastic job, and they've opened it up so that there's less likelihood that dancers will have to be sandwiched in with patrons. The former configuration was a runway in the middle of the bar, and the bar took up the entire room. So I would like the board to consider that as one factor. Number two, the violation of Rule 7 of the adult entertainment rules. There's no touching. It is a rule, but it's the least egregious rule that there is in the adult entertainment rules. It's that the dancer had her top off while in the presence of the patrons. I am prepared to make arguments that I've made in the Bourbon Street case. Number one, and this could take 2 hours to put all this on the record, and prepared to take it to the Supreme Court if necessary, and I don't think that this is the appropriate case to have to do that since it's so mild. But the arguments being, number one, that the entire Baltimore City licensing statute is void for overbreadth, for not allowing for legitimate theatrical performances that provide nudity. The whole thing would collapse. Second part being that the liquor board rules are not specifically authorized by the licensing, especially something like this that's on the minor end of things, not the illegal conduct. I don't want to get into all that. I've been instructed by the client to fight this thing, and I don't want to do it. In light of the fact that they've made substantial improvements, and in light of the fact that we would pay the administrative fee, I ask the board to consider that. The final part is that the inspector has, all inspectors have a certain amount of discretion when they go through a place. The place was orderly. Ms. Brooks was certainly within her discretion to charge it, but she would have been equally within her discretion to say, dancer, cut that out, put your tap back on. And the evidence would show that she had it in her hand. There was no type of conduct or contact going on. She's actually just standing in a group of people. Implore the board to consider that resolution in this case.
We'll go off the record. Yeah, well, I gotta go.
daughter at 5:30, but we'll all right. I understand. All right, Mr. Previs, I mean, we note that this is, looks like it would be, I'm sorry, yeah, let's go back on the record. Mr. Previs, we note this appears to be a first offense. We simply can't, until we hear the evidence, we can't promise that that's going to be our ruling. So we're going to have to deny the request at this time, and we understand. We'll hear from the inspectors. I don't think the board's, I understand what you need to do here, but we can't make any promises beyond, at this point. So we'll hear from the inspector.
Okay. Do you want me to reserve my arguments with regard to the other until you hear the evidence?
Yes, thank you.
Thank you.
Mhm. All right, Inspector Brooks filed a report in this matter dated Friday, September 28, 2012. Did you not?
Yes, sir.
All right, what, if anything, did you observe at the subject establishment?
I just doing a random check of the establishment. I did observe a dancer named Amanda Brown, stage name Alayla, standing in the middle of a group of approximately 5 male patrons with her breasts fully exposed. She was leaning on the arm of one of the patrons and speaking in his ear. I identified myself to the dancer, informed her of the violation, took 2 pictures. Management was also notified of the violation. I recorded all necessary information and left the establishment without further incident. This is the photograph of the dancer, and I gave to the attorney as well.
Wonderful. All right, thank you. Would note that Inspector Brooks, in addition to her written report, oral testimony, also has a photograph of the dancer. No face, just her body, and exposed
Truly
breasts.
topless.
Truly topless. All right. Any questions for the inspector?
Ms. Brooks, Ms. Karen Rathbone is the general manager, and she was there.
I
at the
believe,
time.
yes, I
She
reviewed
was
the call.
quite cooperative.
Oh, absolutely, yes.
Okay, and you had no incident with this establishment since they took over
No.
last year? Okay.
I haven't, no.
Okay. And you, the dancer did cooperate and put her
Yes.
top on? She had it in her hand?
Yeah, she walked to the back dressing area and did get dressed. yes.
Okay. Okay. No further questions.
Thank you. Inspector, is there any other evidence for September 28th, 2012? Okay. Anything? We'll give you a chance to argue on the constitutionality of this matter.
Okay. All right, first of all, to place in the record, Baltimore City Code Article 15, the entire adult entertainment provisions. Also attached there too is a copy of the zoning definition of adult entertainment. If I have that here, here it is. So it's B1 and 2.
Well, we have one, I already put your photos in as one.
Okay.
So we'll have Article 15 of the Baltimore City Code received as the second exhibit, and the zoning, adult entertainment, and nudity definitions as the third exhibit.
And as a fourth exhibit, a complete copy of the Baltimore City Liquor Board Adult Entertainment Rules and Regulations.
Baltimore City Adult Entertainment Rules and Regulations received as the fourth exhibit.
And finally, a copy of the case of Legend Nightclub et al. Versus Dennis B. Miller, and that is a Fourth Circuit case dated February 17, 2011, cited at 637 Federal 3rd, 291.
I will receive the case law, Legend Nightclub versus Dennis B. Miller and Robert Ehrlich, Prince George's County, Maryland, Normal Lindsay defendants.
Okay.
We'll hear from you at this time.
Thank you. The Legend nightclub case that I provided had to do with a challenge by a Prince George's County nightclub regarding Article 2B nudity section that coincidentally does not apply in Baltimore City because of the grandfathering provisions. or the related section. It's the existing adult entertainment establishments are not subject to the
Maryland code.
to the Maryland Code. And this establishment is subject to Article 2B 10405. The establishment, which was an adult entertainment establishment, challenged on its face the Article 2B 10405 as being void under the First Amendment for overbreadth. And the reason being is that there was no exemption or provision in the law exempting and allowing for legitimate theatrical performances that provided nudity. And the court determined that the adult entertainment establishment had standing to make that challenge because of the First Amendment implications. The Baltimore City licensing section that we're dealing with similarly has no exemption from licensing for a legitimate theatrical performance, so it fails for the same reason as Article 2B 10405. And I note that the zoning definition of adult entertainment is significantly different in one point, but it's a significant difference because the zoning definition is whose major business, while the licensing definition is allows. So that the licensing provision would apply to anyone, as I read it, that would provide any type of nudity anywhere, be it a performance of Equus, or a Girls Gone Wild night, or a wet T-shirt night one time at an establishment that doesn't otherwise provide such things. So the first argument is that the entire adult entertainment licensing section of Baltimore City Code Article 15 is void as being unconstitutional under the First Amendment, as providing no exemption under the overbreadth sections. The second argument is that under the Article 15, Section 1.3, the law does provide for the liquor board that they may adopt rules and regulations and forms to carry out the provisions of the subtitle. However, the liquor board, in liquor board parlance, is subscribed, or subscribe's not the word I was looking for, aware of the case of Sullivan versus Liquor Board. Sullivan versus Board of Liquor License Commissioners, 293 Maryland 113, 1982. It says, although the Liquor Board in the Article 2B has discretion to adopt rules and regulations, at some point those rules and regulations go beyond what the statute contemplates and goes into actual legislating. So what we have here in Article 15 is a provision for licensing of live entertainment that provides nudity or partial nudity, and in defining adult entertainment goes into not just nudity and partial nudity, but different types of acts that would be criminal, but they indicate that they are licensing such conduct. The only clear way to read that is that the licensing would go up to and including anything that would be legal and that would not allow for illegal conduct under any circumstance. I don't know how you would read that under any other way. So therefore, you pay $1,000 a year for a license, and it would allow for the acts of nudity or partial nudity as provided in the code. Now, to say that the liquor board, not this board, but the 1999 board, and I specifically remember being at that hearing and saying this rule goes too far because it does not take into consideration the reality of how clubs are run. And we don't have an issue of lap dances in this case. It's just, it's even broader. It's a dancer being in the area with patron. There's nothing in the ordinance that prohibits that. You're licensed to have adult entertainment. Back to the actual hearing, it was discussed and contemplated and ultimately adopted that dancers would have their tops on while performing lap dances. And I commented that I believe the more appropriate rule would be to allow the topless lap dance, not bottomless, so long as the the patron, kept his hands under his legs and there was no touching by mouth, by hand, or anything else. And that was what was going on as far as lap dances, and that's the way the rule should have been adopted. And Sergeant Gentile countered, oh, we won't charge that. We'll use our discretion. Which brought me to the point is you don't make everything illegal and then you can pick who you don't like. You should make a rule that comes into play. Mr. Daniels seems that he may remember
Might have
that
some
hearing as
historical
well.
context for us, so.
But back to my point, I was giving a little frame of reference on this, but back to my point. At some point under Sullivan, the rule goes beyond what the statute or the ordinance would contemplate. So this rule would definitely goes beyond anything that the city would have contemplated. The liquor board to have authority without going back to the city council and say, amend this statute or amend this ordinance and say, we need these things. Thank you. I renew my request. Please, please, please.
Certainly, we'll hear from.
Consider
we'll hear
me.
From certainly Executive Secretary Samuel T. Daniels.
Were you sworn in?
No, but I'm only gonna do an argument. So do I need to be sworn in for an argument?
Only if you're gonna tell us about facts from 1999.
That's exactly what I'm gonna tell you about.
So that's why you have to come under oath.
Okay.
Yeah,
All right.
thanks.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I was at that meeting. I can't give you the date now.
Sure.
But I was at that hearing and I helped, it was Lenny Skolnick's commission. I helped them formulate some of these rules based on the practical experience that we'd had from being in the field. They obviously completed the rules. I think the intent there, and I'm not going to get into any of the constitutional stuff, the intent was to craft circumstances that would limit misadventure. And I believe that both Article 15 that has been cited, Article 19, and then the subsection of 2B, which turned over to Baltimore City the ability to follow Article 15 on this matter, that under all of that, liquor board, all of that, our intention again was to prevent misadventure. And the way to do that would be to limit what a person could wear, where they could wear it, and how they could wear it. And that is all that it is. And I don't, counsel I value tremendously, professionally and personally, tremendous amount of respect, but I'm concerned that his argument was taking us way off in a constitutional direction that I don't think is balanced in its appropriateness for this particular incident. I will agree that we employ discretion, and I will state that on many occasions I personally have seen people touching and not written it as a violation, but I also afford the ability to any inspector to make the determination whether it would be a violation or not a violation, and there's no set standard there. So that's the extent of what I have to say.
Certainly. Anything else you'd like to add?
Absolutely not.
All right. Is there any other testimony or evidence, any other case law you want to submit to us?
No.
No. No. All right. You ready to go off the record, or you want to put some testimony on? right, anything
No,
else?
no testimony.
All right, we're gonna go off the record. We're gonna go straight to our decision phase. There's a case. Daryl L. Simpson, Baltimore Little D's LLC, trading as Little Darlings, 40305 East Baltimore Street, which is at 12203.1 and Article 15, Section 1 through 3A of the Baltimore City Code, specifically a violation of Adult Entertainment Rule 7, which states no dancer may mingle with patrons while the dancer is nude. Inspector Karen Brooks entered 403-05 East Baltimore Street on or about September 28th, 2012, and indeed observed a nude dancer mingling with patrons, the exact factual circumstances that Rule 7 covers. We find Inspector Brooks' testimony credible. Although it's not in evidence, we briefly saw a photo of the exposed breasts of the dancer. We further looked at the Baltimore City Code and the Article 2B, 2005 state adult entertainment guidelines contained in the Maryland Code. And finally, we heard about the federal case in Greenbelt and went up to the Fourth Circuit. I went down to Richmond with Legends, kind of a notorious club on the DC Beltway. They did bachelor parties, all sorts of different stuff. And the case, indeed, in the Fourth Circuit was reversed based on the fact that there was no exemption for theatrical performances. And you also mentioned the Sullivan case, which was way before our time, but indicating that the rules and regulations in that case had also gone beyond the scope of what was intended, and led, indeed, perhaps regulators were becoming legislators in that case. Are the Baltimore City Liquor Board adult entertainment rules and regulations overbroad? I don't know, but I can tell you that this is at least the second time, if not the third, in the last 6 years that you argued this. And I find it a fascinating argument. I do, however, we feel that Rule 7 is probably the worst rule you could pick as far as making this assault on the entire set of rules. Rule 7 is specific. Rule 7, when you're mingling, we don't see how there's a theatrical performance. And I don't want to encourage you to bring us a case with a snake and burlesque and everything else, because then your arguments, I think, have more immediate applicability. But in this case, this is simply restricting the attire of a dancer in a place that's licensed specifically for adult entertainment. So in that regard, we're not going to address the omnibus rules and regulations and to whether or not they're overbroad. We don't believe that there needs to be a theatrical performance exemption to an attire, to a dress code under adult entertainment regulations, where something might be a disturbance or might be a misdemeanor if someone was dressed or undressed the way that a dancer is in an adult entertainment establishment. And then on the inside, she's legal. If she were outside dressed that way, she could be arrested. If she's on the inside dressed that way, under certain circumstances, she is legal. And I think that's a reasonable circumstance that's regulated by the code, is how will the dancers dress when they are not performing, whether it's artistic or unartistic performance. So we do find, indeed, that there was a violation of Rule 7 on or about September 28, 2012. We agree with you. It is one of the least egregious adult entertainment regulations, and perhaps could happen more innocently than some of the other violations of the adult entertainment regulations could occur. In many of those, it requires consent, it requires two people with scienter, they know exactly what they're doing. In this case, what is mingling? Was she going to the bathroom but was surrounded by folks? It's hard to tell, but the eyes of a very good inspector saw clearly what she believed was, in fact, mingling, talking, and not just a thank you, and let me get on my way, but actually to the point that there was a resting of a head on a shoulder, so that it was more of an extended stay, and therefore would get up to mingling in our minds. So we do find the licensee guilty. It is a $250 fine and $125 in court costs. And we know your client knows her rights for judicial review of our administrative decision. So I won't ask you when you'll pay. We know where you are, so we'll need to get that fine unless you do obviously file. All right, thank you very much. It's always a good time to hear you. Thank you. We're off the record.
You did your 2.5 hours.
We're adjourned.
Mr. Rivas?